to gave us a call about a month ago saying, hey, can you come and talk about investment properties? First thing that pops into my head, landlord tenants. So a lot of people who have additional income decide, I'm going to be a landlord, let me find some tenants. So this presentation, what we're going to be doing is just a bit of a cursory overview of some points that we think that your clients ought to know or that you ought to know as well. Now, the wonderful thing with technology and the resources that are available is that tenants have a lot of resources at their disposal. They can become very sophisticated. Information out there is free. They can contact the landlord-tenant board. They will get free advice. There's legal clinics that get free advice. There's online resources such as the landlord-tenant board. The landlord-tenant board has a whole bunch of guides, kind of users for dummies on every possible scenario. So they're well equipped. So landlords should also be well equipped to meet any kind of situation that they might come across in their duties as landlords. So I'm going to pass it over to David, who's going to start, and then I'm going to finish with, I guess, terminating that relationship.
Yeah, so I'm going to get into basically the framework of landlord tenant board. So the actual legislation is the Residential Tenancy Act, which governs the relationship between tenants and landlords. And tenant is defined. So tenant is a person who pays rent for the right to occupy. Okay? It's very broadly defined. It can be a room or boarder. It can include lodger situations. It doesn't include a tenant that lives with an owner and shares a bathroom or a kitchen. Okay, so that's a very kind of rare situation, but keep that in mind if that ever arises in your practice. Now, the RTA has a variety of offenses that are in the Act with appropriate penalties. So things like harassment, eviction without following the rules. You can't, as a landlord, withhold vital services like hydro or gas. You can't enter the unit without a good reason or without it being allowed in the RTA or without giving the proper notice. You can't charge more rent than allowed under the RTA in terms of increases. You have to follow the prescribed rates. So most things that people know. Can't change the locks without prior notice. Failing to pay interest on the rent deposit. That's something that sometimes people aren't aware of, but particularly when we're dealing with a transaction involving tenants, the security deposit, there is a small amount of prescribed interest that we would calculate and adjust for on closing. So just to keep in mind, but the law office would do that on your behalf. Failing to provide rent receipts if requested by the tenant.
So the interest, is that annual? Like if you
It is, yeah. So it's like if you moved in 2010 and the security deposit's been held since 2010, there's interest every year that accrues. It's a prescribed rate, so it changes depending on inflation and so on.
Yeah, right now it's at 1.8%. So if you're repaying that security deposit, you go by the current year. So if the tenant's moving out now, it's 1.8, dating back to whatever, 2010.
Doesn't it cancel out when every year the rent goes up?
It goes forward. Carries
It
forward.
carries forward.
Unless it's been applied to like future rent. So for example, if the landlord at the end of the year either cuts the tenant a check or gives them a credit towards one of those rental payments, then obviously, yeah, it's not going to carry forward. But if none of that's been done, then yeah, you're going to owe interest from day one to the day that they leave.
Yeah. What he said was, like, could you do that where, like, there's an annual rent increase as well? So,
Yeah.
like, let's say you have the rent deposit, like a security deposit for 5 years, and there's also an annual increase.
Right.
So you could just have an agreement with them that the rent in 5 years, when they move out, you're gonna have to use the deposit for the last month, which will be short now because of the annual rent increases.
Yeah, like they're supposed to top up their last month's rent, aren't they?
Not necessarily. No, like you could okay, let's say in 2010, I pay $1,000 as my last month's security deposit. I move out in 2018. If there's been no credit to me for that $1,000, the interest on that every year, then that accumulates all the way up until the moment that I leave. And then that landlord has to pay me back that interest on there, not only applied towards my last month. But you have to also do the top up, whatever the difference is for that year. So if now current rent is $1,500, then I have to pay the difference.
Right, okay.
Okay. Yeah.
Notes as well, key deposits are illegal, damage deposits are illegal, but the last month's rent is perfectly legal, okay? We collect that. And then we touched already on the interest,
It's so weird, because the Ontario Standard lease has a key deposit section.
does it?
Yeah.
Oh, really? Because that's what they put
Yeah.
online. So,
If the keys are worth money, that's what it is. Like, that's for condos, right? If, you know,
Right.
Oh, maybe it's an exception for condo.
Yeah.
Okay, maintenance, so landlords are required to maintain the property, obviously. It's not sufficient to just say the tenant was aware of problems in advance and we're just gonna close our eyes to that. And you can't rent on an as-is basis. Privacy, as a general rule, the landlord cannot enter the unit, okay? They can if there's an emergency, obviously, and if the tenant agrees to it and has the proper notice. So you have to give 24 hours notice, and the attendance should be done between 8 a.m. and 8 p.m., okay? Not before 8 a.m. and not after 8 p.m. And, you know, it has to be for a legitimate purpose, to make repairs, or if you need some sort of an inspection done, and so on, for insurance purposes. Okay, terminating the tenancy, I think.
So just before we go into that, so if you're selling a property with tenants at the unit or dwelling, whatever the case may be, just because you have the legal requirements that say 24 hours notice between 8 a.m. and 8 p.m., doesn't mean that you should probably follow that. Maybe you should give them a little bit of grace, just because there's nothing like showing the property to potential purchasers and having a really pissed off tenant that's going to sabotage your viewing. And we see it happen all the time. So just keep that in mind. Even notice requirements, even though you're only required to give 60 days notice, your tenant can be your good friend and one of your worst enemies. So really good to kind of get on their good side. Probably tell them well in advance of listing that your intentions to sell the property. Just because if they're not on board, there's going to be a lot of problems. And the landlord-tenant board is, to put it lightly, highly in favor of tenants, very protective. So they will bend the law backwards to ensure that their rights are protected or that they're not overly inconvenienced. So especially if you take a set of facts, you have a young family with a small child, I don't know, you toss in some other kind of sympathy cards in there, an adjudicator is going to do whatever he can to kind of stretch the law in that person's favor. So whenever you're kind of in that situation where you're selling with tenants in the property, make sure you get on their good side and you give them ample notice, because they can make the process quite difficult. Okay, so leading into that, so if you want to end the tenancy, there's a variety of different ways. You can end it as a tenant at the end of the term. So if it's a 1-year lease, the tenant can give 60 days notice that they're ending that lease. After the 1 year, it goes on a month-to-month, but as a landlord, you can't just end that lease. Even though the lease is expired, it goes on a month-to-month, and unless you have a legal ground to terminate the tenancy, that tenant's not going anywhere. Okay? So in terms of how we count the notice, so It's 60 days from the first of the month, or from the start of the rental period. So today's June 4, so if you were to give 60 days today to your tenant to move out under one of the categories that we're going to get into, you'd have to start from July 1st. So July 1st, and then the move out date wouldn't be until August 31st. Okay? Now,
ERTO.
so there's one of the two ways that a landlord can end the tenancy is landlord's own use. So the landlord says, I need the place for myself. So there's a few categories that fall into that. So you can have the actual landlord that needs it, the landlord's spouse, or the landlord's child, or parents, or a caregiver of one of those groups. Okay? Then the landlord or one of those groups has to move in within a reasonable period of time. You also have to give 1 month rent in terms of compensation. And let me just skip ahead. Yeah, so I covered all those points. And they have to live there for at least 1 year. So if you don't meet any of those requirements, and for example, your landlord moves in for like a month or two, and then decides that they're going to relist it, or they're going to, I don't know, demolish the place or sell it within a month of living there, then there's the former tenant can come to the landlord-tenant board, and there could be some hefty fines and penalties for that landlord.
What if the scenario is the buyer intends to buy the house to move in, something happens? I have the exact same situation, they split up. So say somebody ends up buying it anyway, or the father comes in to rent it now for a year. But it was tenanted before they bought it. So they bought it with the intention of moving in, and that fell apart. Now they're moving in, they have to buy it anyway, so now they're gonna rent it. Can the tenant come after the buyer?
No. So long as somebody moves in within a reasonable period of time, and it's not defined what a reasonable period of time is. If within that year the new purchaser sells it after moving in, or they re-rent it, then you're in the clear. But the main requirement when it's a purchaser's own use is that somebody has to move in within a reasonable period of time.
No, but if they don't move in, they're just gonna rent
And
it.
the former tenant's on the line.
The former seller,
Sorry, that's what I meant.
can the seller come after the buyer?
They can, and that's why it's a good idea. Yeah, I was going to get into that. That's why it's a good idea to just get an indemnity or some type of warranty that the new purchaser will occupy it within a reasonable period of time. What's a reasonable period of time? I don't know, 30, 60 days? Yeah.
So if you've told the tenant that the house is going up for sale, presumably the buyer will move in, but it hasn't been listed yet, and you ask for an N11,
Right.
does that protect the seller?
I've seen an 11 signed, and then the person doesn't move out. And then good luck scrambling to get an eviction hearing at the landlord-tenant board, which can take weeks. So what I've heard some individuals do is when they get that N11, if they have any kind of doubts that this tenant's not going to move in, they actually book the application to get them evicted the moment they get that N11 signed. So that if for whatever reason they don't move, then you have the hearing booked just in case. And if they move, the hearing is irrelevant. You don't have to attend.
Sorry, maybe, I meant under the situation where the tenant was asked to leave. The
Right?
buyer buys the property for
Right.
investment purposes and puts it back up for lease.
Right.
But you've got an N11 where the tenant has agreed to leave. The seller's not on the hook for that future lease.
No,
Okay.
no, not at all. No, not at all.
Okay.
The other kind of advantage to the purchaser's own use is you don't have to pay that 1 month rent to the tenant. It's just the 60 days. So, yeah, so
Yeah, like I was just involved in sort of an interesting situation where before selling the property, they decided to sign a 1-year lease with these tenants. And
the
then
purchasers did?
the sellers,
Oh,
they
okay,
decided to kind of give them an extra year.
okay,
And then at the same time, they got them to sign an N11, right?
right,
So, you know, I know that they can't be signed simultaneously, so we kind of put a bunch of clauses in the contract saying that, you know, they weren't coerced to do this, and, you know, they weren't signed at the same time, and, you know, the tenants voluntarily done it. The lawyer that we're working with asked for sort of an estoppel certificate,
yeah,
so I was just wondering, like, kind of what the legality of that is, like,
Sure.
you know, to make sure that they're
so
protected.
when you're selling, if you're on the buyer side, what you're gonna want to get from the seller is, you're obviously gonna wanna see a copy of the lease. You're gonna wanna see what the terms are, okay? The other thing that you mentioned is, yeah, it's called a tenant estoppel or a tenant acknowledgement, okay? So this is usually like a standard form which sets out the terms of the tenancy. So it'll say, this is the monthly rent, this is what I paid in a security deposit for last month's rent. No, I haven't, the last month's rent hasn't been applied to past rental periods. No, the interest on that has not been paid to me. I don't have any claims against the landlord for any, I don't know, any issues with respect to repairs or claims against reducing the rent. So it's kind of like a confirmation from the tenant, signed by the tenant, that the terms of the tenancy are as such, and so that you as a purchaser will then, if the tenant ever has any claims, you're like, okay, well, you signed off on all these terms, like what's the dispute here? So you can't make a claim once, like you.
Is that more legally binding than an N11 kind of form, or like?
You should have both. Yeah, you should have both. The other thing that you'll want to have in an agreement is a direction from the seller advising the new tenants that future rent is to be payable to the new purchaser. You probably want to set out the terms of the current rent in the agreement and the schedule. So the current rent for this unit is, I don't know, $1,200. Utilities or what have you are not included. You should address the fact if there is a last month's security deposit with the seller, because that's going to have to be adjusted for on closing. Because on closing, that security deposit is going to be given as a credit to the new purchaser. Because now when the tenant leaves at a future date, it's going to come out of the pocket of the new purchaser. The other thing to kind of keep in mind is not a bad idea to just confirm that any rental increases have been done appropriately. So there's certain procedures you have to follow when you're increasing rent. So the current rental rate is, interest rate is 1.8% per year. Again, that changes. However, you do have to give the 90 days written notice that you're going to increase the rent. If you're going to go over and above that, then you have to get the landlord-tenant board order with the written justification that, I don't know, your property taxes went up exponentially, utilities went up, what have you. So if you haven't increased rent properly, it's very possible that a tenant can apply to the landlord-tenant board to have the original rent reinstated from multiple years ago. So you as the purchaser will want to make sure that whatever increases were done properly, the notices were given, because you don't want to be in a situation where you're under the impression that rent is $1,500. This person's been there for 10 years, and then they somehow make an application to the LTB saying all those rent increases over the past 10 years have been invalid, and the landlord-tenant board reinstates the original rent of $1,000. So just something to keep in mind.
So you need to get as a buyer a record from the landlord of all the proper increases.
You should, yeah, you should.
What if someone doesn't keep stuff like that, like,
That's
most people
part of the
don't.
reason why tenant acknowledgement or estoppel certificate is helpful.
Yeah.
In the real world, people don't have that type of documentation, right?
Oh.
Or most people.
So on the buyer side, you would ask for the stop to get from the
At
tenant.
least you have
So the
some,
current's acknowledging
exactly.
that rent
Acknowledging
and they
that-
can't go back on it.
Exactly.
Oh, right, okay.
Yeah, because that's a very good defense.
right, because they're signing off on it, right? The tenant is
Right.
basically representing that this is true, these are the terms of the
Oh,
tenancy.
okay.
So that at least gives you some comfort, right?
Right.
Yeah.
We'll move on.
I think you covered most of the stuff, but.
Okay, just the other thing, in terms of landlord's own use. So just so you know, if the property is owned by a corporation or a number company, you can't give that landlord's own use application, that's irrelevant. So just keep that in mind if one of your clients ever holds title that way, that they can't give a landlord's own use application. Sorry.
So what if you have people, I have actually two people wanting to buy like a duplex or something. I've got it, wondering when they're buying together, what is the best way for co-ownership? Like if you don't do a numbered company, if you can't kick out a tenant with that reason, you have to just go in as two individuals.
Right. That's a whole,
But it goes to the matter of title, like, are they gonna be 50-50% as tenants in common?
Yeah, I think.
Or you can do, you know, sometimes we prepare trust agreements or co-ownership
Yeah.
agreements, those are becoming more and more,
And then with
popular.
that, you can actually go own, like move out tenants for your own use,
Absolutely, yeah.
right? But just not a numbered company.
that's right.
that's right.
Yeah.
How would they know?
That's gonna be their number.
Yeah. It'll be the numbered company on the lease.
Or if they ever did a search of title and they saw the registered owner was a corporate entity, you're done. That application is out the window.
What if the lease is made with a property management company?
It doesn't matter. If the property's owned by a corporation, then, yeah.
Yeah, if they don't know, they don't know. They might not know and they might not be the wiser, but it's illegal, basically, right? So if they find out, then you're gonna have problems. I think the last.
Okay. Last kind of point, it's been very popular in the news lately is this whole rent evictions. So where landlord tells their tenants, you know what, I need to do some renos to the place, so I'm gonna need you out. So in that kind of process, you have to give 120 days notice. You have to have a building permit and require vacant possession of the property in order to justify using this room. But what's happened is a lot of landlords were abusing this provision and they're just getting like some cosmetic, like a building permit. I don't know, I'm gonna change the floors, maybe update the kitchen slightly, do a new paint job. They get the tenants out and then they re-rent based on current rates, which sometimes can be significantly higher than the former. So technically, under the Residential Tenancy Act, you have to offer the original rent to the former tenant. And if you don't, I don't know if you read in the news, you will get slammed with fines, and they will make an example out of you. And yeah, you don't want to be in that situation.
Except the case on that College Street one, I mean, all
Yeah.
of the news is that they didn't care. They
Yeah,
already had it rented out to new tenants, and those tenants' rights then now trump the old tenants' rights. And
Yeah.
they did it on purpose, they knew that whatever the fine was still going to be.
It was the cost of doing
less.
business.
Yeah, cost of
Yeah.
doing business and it's
There was
less than
recent,
that.
yeah, there's a recent one, the fines were like 75,000, which in the grand scheme of things
Yeah,
is,
they knew they were still going to be making way more. money.
especially if you have like a multiple unit building, like in that case, especially on College and
Yeah.
Dufferin, I think it was. that area, yeah, it's the cost of doing business, so.
So, and it doesn't make sense to renovate with a current tenant if you have to offer the former tenant the unit back at the price that he was paying previously.
Exactly. That's kind of the disincentive to doing this kind
Or
of
just
thing.
know you're gonna get hit with a fire.
Yeah, or fine with that,
It's like cutting down a tree.
So I think we've covered like the main points. Again, like David and I were not like experts in landlord-tenant board issues. Usually if there is a landlord-tenant board issue, we refer it out to a paralegal. However, we are very good issue spotters. If we need to specifically look into a matter, we're very resourceful, we'll get the answer. In terms of, did you have anything?
I think if there are any questions or comments. But it is interesting, though. I don't know, has anyone ever been to the landlord and tenant board for a hearing? You have, okay. Yeah. But it's an interesting experience to go.
Yeah.
A little
Just
bit.
even just the.
You can do everything right as a landlord. If you haven't put the post code in as part of the
Oh,
full
yeah,
address,
yeah.
it doesn't matter for
What?
Yeah.
What? What do you
So
say?
make sure you include the full
Yeah,
address.
Yeah.
Otherwise, it doesn't matter that you've done everything
So
else.
you've been.
In
so you
the, what,
understand
in the
it.
lease?
They're very good.
Or, no, on the forms. like
Everybody's there protecting
Oh,
the
that's
person,
happened.
Yeah.
and you're by yourself.
Tenants are so sneaky.
So the N11, do you have to first issue the N12, the notice of eviction, then the N11, or not just straight ahead with the N11?
One or the other.
But you can just give you don't need to give a notice of eviction
No.
before you give the N, like have it, the paper. the-
Yeah, obviously, if they're not gonna sign the N11, do the N12, right?
Right.
But make sure you've calculated the amount of time,
Right,
right?
okay.
Because, for example, if you decide that you're gonna give the notice at the end of the month, and you're calculating 60 days from there, that 60-day calculation is gonna change altogether once you get into the next month.
And how do you prove that they received it? Like if they say, well, we gave them the N12 and the tenant just said, I never got it.
Oh, the N12, if you look on the landlord tenant board site, there's various ways that you can serve the document. And then usually the person that serves it will sign an affidavit confirming that
Swear
they
an
served it.
affidavit
Yeah.
that you served them properly. Just saying, I so confirm, solemnly declare that I served blah, 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 this date.
Oh, okay.
And you have to get that, you swear that in front of a lawyer or a commissioner. It's an
So you have to get
It's
somebody
a sworn
else
statement.
to serve the N12?
It doesn't have to be.
No, you can
Doesn't
do
have
it
to be.
yourself, but you just have to follow the proper form and procedure.
Oh,
It's
okay.
all on.
Okay,
So
so.
the LTB it's designed, again, it used to be in the court system, it's designed to be user-friendly, so most of the stuff, pretty much all of the stuff you can find online, and they're actually really helpful if you call them, the landlord tenant board, they will kind of guide you along. You might have to wait a while
Yeah.
on hold, but they're really good. And there are guides that kind of give you the whole process.
Um, If it's initially an amicable, we're selling the house, we kindly ask you to leave, here again 11, and everything goes well, it's a nice email, are there standards to which that notice has to be given? Like, is an email saying, here's what we're doing, here's the last day of the month, we're asking very nicely for you to leave, included is the N11, please sign and acknowledge that you're going to be elsewhere on closing?
I would say so long as you get the N11 signed
Yeah.
and it's properly filled out, then I would say that's sufficient.
Okay.
But if it's the other way around, where you are the one that's giving them notice and it's the N12, you better make sure you follow the proper service protocol, because they'll call you out on it.
Well, just sort of what I've noticed lately with a lot of homes that are for sale, that are rental properties where people want to have it taken possession for the sale, they'll approach the tenants and they'll say, there's two options here. You can stay in the place, but if the new purchaser offers the N12, you're going to get no compensation, or we'll give you 3 months compensation to sign an N11. And I find like there's a lot of people that are evicting tenants with 3 months rent. It's like, seems to be like a going rate. And basically from their perspective, like, they run the risk if they try to stay on. If the new purchaser wants to move in, they may end up with nothing at all, with
we're gonna give you 60 days notice and 10 grand?
Well, we're gonna give you 3 months, 3 months rent compensation to move out.
How long are you giving them to move out?
Well, once they sign the N11,
60
it's 60 days, but they can shorten that to 10 days.
So will you do that before you list the house and make so
That's
that
what, I
empty
haven't done it, but
yeah.
that's what I've seen in a lot of
Yeah.
properties, like, because we all almost bid on a couple of properties, and we were like, how did you vacate these tenants?
Mhm.
And that was the situation, is they approached them and they said, look, there's sort of a 50-50 chance that the next purchaser wants to move in.
Yeah.
If so, you're gonna get booted, and because you don't have to give the compensation, you're gonna get nothing. Otherwise, we'll give you 3 months rent right now, and you know, if we mutually agree to move out.
I have a specific question. I have a client who's thinking of selling. It's a semi in the annex. Basement was a rental apartment, non-legal, non-conforming when she bought it, just continued use. But she renovated the upper floors as 3 units with permits for rental.
Okay.
So it's now 4 units, which means technically you can't evict anybody, correct?
Yeah, I think that's right, it's like a 3-unit max.
Yeah.
I actually
Yeah,
thought it
Rules
was out.
change.
Right.
Yeah, the
Yeah,
rules
so-
change, 3 and under, but yeah, you're right.
So 4, but if one of the one of the suites is owner occupied, can you qualify it as 3 and ask for vacancy?
I don't think so. I just investigated that situation, because that was another one that we were bidding on, was a 4-unit property, and you cannot deliver the notice on behalf of the purchaser, but if you took possession, you could deliver the notice on behalf of the
After
owner.
closing.
So you could do an N12 on a 4-unit property, but only if you're the current owner.
Can I ask for an N11 on a 4-unit?
You can see if they'll sign it, I think, right? Like, you can always ask them, they don't have to, you can ask them
Yeah,
to
we'd have to
terminate
look
their
into that a little
tenancy.
bit more, in more detail.
I don't even know if you're allowed to ask. That's what my concern is.
I've given people
It's a
them,
mutual
say,
thing.
just in case the tenant, or I've given them to current tenants where I wrote the lease for them and the owner lives in the other unit, but they always knew that their daughter might move in. But, and like, I just asked them to sign it, and they signed it, so,
Yeah, but this wouldn't be owner use, this would be for sale.
oh, then, yeah, I don't know.
A lot of times, these issues all boil down to money.
Yeah.
Tenants want to be compensated, so you gotta think in your head and run a calculation, how much is it gonna cost me to force this person out in terms of fees and potential penalties, and how much is it gonna cost me to just pay them? A lot of the times the payout is much less than what you're gonna expend in terms of time and money to force a tenant out. Not to mention if you're on the selling end and you've promised vacant possession, you don't want to be in a position where now you're not only accountable to the tenant, but you're going to be accountable to the new purchaser who you're failing to give vacant possession. So you got to be very careful with how that plays out. Most of the time, it's always best to come to some type of mutual agreement. I know it kind of sucks to cut a check and pay someone out, but a lot of the times it makes much more business sense to do so.
How do you legally, if you're cutting a check, what if they still don't move? Like, how do you make sure if you're paying them that they actually move?
Well, you get the N11 signed, and if you're really paranoid, you get the application ready and booked for eviction.
Yeah, okay, but then you also show
Simultaneously.
that you give them money, they receive.
The other thing is
Yeah.
to use a lawyer, right? You can always
Yeah.
use a lawyer and put the money in trust.
Yeah.
So that their lawyer is not to release the funds until
They're out.
confirmation that they're out.
Yeah.
If you don't use a lawyer, then
Yeah.
you can always, even if, I'm sure,
The
yeah.
tenant uses a lawyer. I've never heard of a tenant using a lawyer.
I'm just saying, if you're concerned that they're gonna pocket the money and then not move out,
Yeah,
a good way to protect against that concern is to have them use or put it into a lawyer's
Yeah.
trust account, right?
yeah. Because you could probably just deal with both ends, like you
Yeah,
contract
you
the
can.
tenant, go, listen, I have some money here.
Right.
When you're moving out, I will, like, give you this money. Yeah, that makes sense.
So, yes,
I was just wondering if you guys have any advice sort of on investing with partners and sort of how the different structures you normally see people set up kind of joint venture agreements or, whether it's setting up corporations or, maybe just some pros and cons on that.
Yeah, we're seeing a lot of people that are getting together who can't afford on their own to buy a place. So I recently just had like 2 couples go in together to buy a place. They're both going to live there. They set out all their rights and obligations. Okay, who's going to live where? Who's going to pay what? Who's going to have what interest? So it's always best in those sorts of situations to have a co-ownership. Joint venture, I like to kind of use more along the lines of when it's like it's a business kind of investment. Co-ownership would be more along the lines of when somebody's actually, they're buying to live with another individual and you want to set out everyone's like rights and obligations. How do you get out? What happens if somebody wants to leave? If they want to get paid out? Like what notice do you have to give? So either way, you should have everything documented. Some people will set it up in a corporation or shareholders, they have a shareholder agreement. So there's a wide variety of ways that you can have it set up.
I just want to know, like, I mean, is it normally sort of coming to you guys and you guys will sort of flag for what questions you normally need to ask, or is there a way, like, that's what I'm trying to kind of get my head around, is like, like what are even the questions to ask and those type of things, right? Like,
Well, we always tell a client right off the bat, how do you guys want to hold title? We explain the differences between joint tenancy, tenancy in common. Is this going to be more of a business relationship, or is this a family venture? And then kind of based on the answers to that, then we'll propose some options. Most of the time I find people that want to get into those type of investments and really kind of have a rough idea. And then it's just our job to kind of vet it and say, okay, I think you're looking for this type of structure. You propose it, try to dumb it down. Yeah. So I can't say that there's like it's very fluid. It's usually just a conversation that we have.
yeah, no, but I mean, you just made an interesting point there, saying that you can't evict people if it is another company kind of thing, right?
Right.
So, if you are investing with, say, partners, and one of the partners in that group may also want to have that place as a residence at some point, then it sort of automatically defaults to going to the kind of tenants in common or joint tenancy type of situation.
Well, no, I tell them if, for example, that they're going to hold the property and they're proposing to do it by way of corporation, I'll tell them off the bat, look, you guys have a plan on doing landlord's own use, forget about it because it's a corporation. So I know you might have some tax benefits doing it this way, but if you ever want to go down this route, you won't be able to. Did I answer?
Can you
Sort of, I mean,
incorporate after?
the alternative way would be to go to kind of a tenants in common kind of
Yeah,
situation.
tenant in common just means you specify the shares that each individual has. I don't know, you and I have a property together, I own it 60, you own it 40, or whatever the split is. And then in conjunction with that, we can have a joint venture agreement or a co-ownership agreement, depending on what our purpose is, our intention.
I just have a quick question for you. Let's say you guys buy the property under a corporation,
Yeah.
and a few years later you own it 50-50, and a few years later, like, you decide to move to England and you want to sell it. So could you just take over the corporation 100% and not pay land transfer tax?
Yeah, for sure. Yeah, because the corporation is the registered owner. You're not changing the registered owner there. You're just kind of changing the shareholders like behind the scenes. But that's an internal change. You're not updating anything on the land registry system. It's still in the corporation name. So
Sorry, did you say you're selling your share?
Yeah, like,
to
let's
somebody
say, like,
else?
yeah, to the same owner.
What's the
It's a sneaky way.
Oh,
that
to
we
another,
work
you
together.
can't bring in another person
You could
Not-
theoretically you could as
and
well.
not pay land transfer tax?
yeah,
Yeah.
Yeah, for
it's a
sure,
sneaky
because
thing
the
that we work
corporation's
together.
not
Buy the
changing.
company instead of buying the property.
Well, to buy shares
Oh.
in the company.
Okay.
Yeah,
yeah.
the corporation owns the property, right?
Okay, can I ask a question? If you're selling a property with a tenant in there, and it's on, they're on a month to month, right?
Right.
I always thought that you just give them the M12,
You can add that in the if you sell.
and when you sell
You
the
can.
property.
You can.
Or, so you should, what, are you advising to give the N11 and the 12?
No, I'm saying
I
N11's
don't know.
the best one.
The N11
Because
is
that's
the best?
signed by the tenant. It's a mutual agreement to
Okay.
end the tenancy
Yeah.
by a certain date.
Yeah,
The N12, they're not agreeing
yeah,
to move out,
yeah,
and then you're serving them with the notice saying they
Yeah.
have to get out.
yeah,
Okay, so it's always best if they sign off agreeing to a date,
right.
than you having to give them notice to get out by a
But
certain
if
date.
you give them the N11, but they have to sign, they'll probably want money, right? But,
Sometimes, yeah.
Sometimes,
depending
not
on-
always.
Not always,
Okay.
yeah.
all right,
Yeah, I think the N11 is, that holds up in court, like if that's signed, there's no way of keep staying, them staying, like the court will, they can evict them, it's binding, right? Like,
For the most part.
yeah,
Yeah.
mostly.
But if they don't choose to leave,
Like that will
Then
withhold,
the-
it's
the-
They
held
can
in
still
court.
dispute it if they really want to.
Yeah.
so I think.
Yeah.
Yeah, they could come up with a
Could say, like,
sob
they were
story,
coerced
oh, I
or-
was forced to do so, I didn't know what I was signing, I didn't get independent legal advice. There's a whole,
Slew
yeah,
of arguments.
so, yeah, it's not a slam dunk, nothing is, like in landlord tenant, but, yeah, that's just the,
if you're, say, for instance, you're looking to get into investing in real estate, own properties and rent them out, so you hook up with a partner. So say myself, I hook up with somebody, buy a house. And then 2 years from now, I want to continue this. So to create, eventually have maybe 5 or 6 houses over a span of, I don't know, 15 years or something. Is it best to form a corporation, or can you just do it individually? You invest with this person, and maybe 2 years later, you're investing with somebody else, and continue that way. Is there any advantages or disadvantages to that?
there might be some advantages from like a tax perspective. We always tell clients to just consult with their accountant.
Right.
Yeah, so there might be some benefits doing it that way, but I don't really see anything
Yeah.
from like a legal perspective.
No, it makes no difference. What I tell clients is consult with their chartered accountant or their tax advisor to see from a tax point of view which one is more beneficial depending on what their plans are, right? But otherwise, yeah, there's no real difference in terms of legal ownership from a legal point of view, but from a tax point of view, there are implications.
Right. What about switching, if you've done that with 3 units and suddenly you want to form a corporation with those 3 units? I guess that's,
that's a tax
Yeah,
thing,
yeah,
that's a
yeah.
tax thing.
okay.
Again,
And at
that's
the
why.
value of the property too,
Yeah,
right?
exactly.
Okay.
But you have cards,
Mhm.
I'm
Yeah.
sure most of you know, but our office is right on Bloor by Dundas, Bloor and Dundas. We're on the south side, always available, just give us a call, you can check out our website too.
Okay.
So if you have any questions or, again, bounce any ideas,
He's very good that way, because
let us know.
Send
Yeah, we're always,
questions to him.
either Daniel or I are in the office, so
Okay.
if you ever